Hello, and welcome to the internet's most passionate show about business litigation. I'm your host, Jesse David Eisenberg, and I am a New York City attorney that specializes, maybe the wrong word, who solely practices in business litigation. Can't really say specialize according to the rules, so that's why I hesitated there. Not that it matters. I'm trying out a new intro. Let me know if you guys like it better. I need to practice saying it by the sounds of it, but I'm going to move forward. So I'm going to talk about a little more practicality today. I haven't really gone into that yet, but this is, by the way, the 12th episode of Business Litigation TV, and we're going to be talking about contracts, and specifically breach of contracts today. So breach of contract is probably the most common business litigation. It can be really simple. You know, we had a contract where I'm going to give you $100,000 and you're going to give me 100,000 pieces of product. You gave me the product, I didn't pay you. Breach of contract. Boom. Take me to court. That is a very, very common case. So, breach of contract is simple. Number one, you have to have a written contract. And if you've listened to any of my other videos, you know I firmly believe everything should be in writing. So now you have a contract. Now, to have a case for breach of contract, you have to perform. That means if you say, I'm not going to pay you, and they go, well, I'm not going to paint your house, and then you can't then turn around and sue them for breach of contract for not paying the house because you didn't perform either. So you have to perform if you're going to sue for breach of contract. Now, they have to violate a term of the contract. Again, really simple. You painted their house and they won't pay you. That's a violation of the contract right there, breach of contract. So again, the elements of breach of contract are pretty simple. There's a contract, one party performed, one party did not perform. Now there's permutations to that. You know, you could have anticipated breach. You know, you have a contract where I'm going to paint your house on March 1st. And February 1st I say, I'm not going to paint your house. That's an anticipated breach of contract, and you can go ahead and sue them if they've told you, and specifically, hopefully in writing, hey, I'm not going to perform according to the contract. Again, so what would be a defense to breach of contract? A defense is, again, if you're being sued for breach of contract and they didn't live up to their end, that's a defense. Another defense is something we call unclean hands, which is, I am suing you for not paying me to paint your house. But your defense for me not paying the house, for non-payment, is that I didn't paint the correct color or something like that. You had an agreement it was going to be a blue house, they paint it red. Well, you're not going to pay for that. You know, they didn't perform pursuant to the contract. You didn't perform. You both did something wrong. Unclean hands. You can't sue for that. I mean, not that you can't sue that. That is a defense that could help you win a suit against you. What would be another defense? The time to perform has expired. Or let me be more specific. The statute of limitations has run. Okay? Now, this is a little harder to get away with because the statute of limitations for a breach of contract, breach of a written contract, is 6 years. It's the longest statute of limitations there really is in the civil courts. So if I don't pay you for painting the house, you can wait 5 years, 364 days to sue me for the payment. At 6 years and 1 day, you can no longer sue me for non-payment. Your chance expired. Okay? You had your chance, you had 6 years, you didn't do it, statute of limitations is run, that's a defense. Now this one I believe, because I don't know it off the top of my head, but if your contract is not in writing, it's a 3-year statute of limitations. And even then, there's a lot of contracts that have to be in writing. Okay, contracts like the sale of a house, buying goods over $5,000, anything that can not be done in 1 year. So that one specifically, if you have a contract that calls for 2 years of action, whatever it is, you're going to deliver something 1 year and again the next year, and that's all in the same contract, it has to be in writing. So those are things, and that's called the statute of frauds, which basically says you have to have it in writing. Now there's a lot more nuances as well, for oral contracts and statute of frauds, and I'll do an entire episode in the future about what to do if you don't have a written contract, if the agreement's oral, and that'll be in the future. But for now, those are kind of the basics for a breach of contract. If you have a breach of contract issue and you want to discuss it with me, you can email me at Jesse, Jesse, at JDElaw. That's JDELAW.NYC. All right. Until next time, I will see you in the future.